think it's time to have the debate with the audience. And of course, all the speakers today are part of the debate as well, and I'm pleased that they are still around. So who wants to start? And who has the first question?
I had one comment I want to make.
Or a comment?
I take my, just real quick.
But we want to have the audience.
I know.
So,
The microphone.
It's on.
It's on. So I just wanted to take this point raised about the presumption of validity. The idea, I mean, this is to me the core of the debate is what is the patent? You know, is it just a probabilistic right that gives the owner of the patent the ability to try to keep the generic off the market, or is it something more? And it's, you know, thinking about this, there's an analogy that we sit around and talk about these things. One analogy struck us be like someone, you know, you have your deed to your house. You have an intruder that comes into your house. And if you follow the commission's approach, it means you have to go to court and get the court to uphold your deed before you can get the intruder out. And you can't just pay the intruder to leave. So I'll just throw that out and let you think about it.
well, I will not respond directly because I want to have questions from the audience. And I mean, we could discuss the presumption of validity of patents. I think there is a lot to say on that. But one of the problems was, I think, pointed by Joseph, is the fact that with the system that we have adopted in Europe, following the bifurcation model of Germany and Austria, we will have a complete gap in between the analysis of infringement and the validity issue. So you might get decisions on infringement without any analysis of the validity. And in that case, of course, if you settled in relation to the infringement procedure, because you cannot have within the same procedure a challenge of the validity, I think it changed again the issue. I think that means as well, I think that patent settlements in Germany might be treated differently because of the peculiarities of the patent system. But there is a lot to, yeah.
Okay, I'm an Erasmus student of UCL. I'm an Italian student, and I would like to...
Student of mine.
Yes. My name... Well, I would like to ask you how a value transfer would be able not to delay the entrance of the generic firms, and if so, why originator companies are willing to settle and paying.
Can you repeat your question?
Yes, of course. If we say that payment transfer is able to anticipate the entrance in the market of a generic company, how it is possible that the originator company is willing to pay to enter the market in advance? In a value transfer, we have the originator company who has the patent, and we have the generic company, right? And this is the originator company that give money to the but we said during the conference that it's possible it's possible that this value transfer anticipate the entrance in the market.
But the point is, you don't enter immediately. That's why you don't get. That's the idea. That's what I was trying to say. But I'm glad you're asking the question because often it's confusing. It's not a cartel. If there's no cartel, there's entry immediate. But that's not the point here. You still have someone who has a patent. Okay. So if you enter, you will end up in court. Okay, so don't think that because you don't sign the agreement, you're just selling generic tomorrow. That's not going to happen. Okay, you have a probability of ending up in court and being injuncted, for that matter. Okay, so it's not so easy. There is that's a very big difference between a simple anti-competitive agreement where we just collude and cartelize the market. This is not the same story, because here you have a patent, and that patent gives the right, I mean, whether it's probabilistic or not, regardless. The point is, I think it is probabilistic, but it gives the patent holder the right to sue. Therefore, the generic, if it does not accept the settlement, may not sell tomorrow at all. So consumer may not benefit. The whole point is you have to assess entry not relative to what would happen absent the agreement. And absent the agreement might be going to court. And the court will tell you whether you enter. Okay? So that's very different. And the court entry date, and that's the real point we're making, the court entry date may be later, okay, than the date of entry under the settlement. Hence, we said, by paying the generic, you can have a generic entering earlier than he would have if he had gone to court to try to enter. That's the whole point.
My name's Jonas Welge, and I'm from a PhD student from Germany. And I was wondering, you said that it's the court that decides when the generic company can enter the market. But actually, like we've heard from this gentleman here, it's not the court that decides. It's for example, in the US, it's the FDA, which gives automatic approval 30 months after the infringement suit's filed. So isn't there a definite date there, at least in the US, which you can calculate with?
I think that the difference, if I can, is that if you have the ability to enter once the 30 months has passed, if you've served your certificate and if a lawsuit is started, you enter at your own risk because the lawsuit is pending. And the point that Benoit is making, which I think is that the payment, the disagreement between the parties has to do with the likelihood of success in the lawsuit. This is why, as Benoit keeps saying, having the patent there makes a difference because you're rolling the dice. It's not necessarily Russian roulette, but nonetheless, you're gambling in some sense. Right, because as the generic, you can go onto the market, but if you lose that lawsuit, then you might pay the 1.2 or 2.4, whatever $billion in damages that we heard about in that Pfizer suit. And so the generic has a risk there, and one of the ways of mediating the difference in what they call the asymmetry in knowledge about what's going to happen in the lawsuit is to have a payment where you still enter, but you enter at a later date than you would have done, which of course would have been, if you were risk averse, the day after the litigation finishes. Okay, does that make sense?
Yeah, of course it does, but that only explains why the parties do settle, but it doesn't explain why we can't calculate any consumer damages. Because we could calculate with that date to see if
Well, there's no consumer damages until the time when the generic enters. And so if you actually went into the facts and said this is a generic who is only going to enter at the day that the trial judge gives his decision or her decision, then that's the date and not the date that the ANDA becomes valid.
James Killick from White & Case in Brussels. I had a question about the relevance of the size of a payment in a patent settlement under EU law. We heard from John earlier on that that's the key part of the activist test. As I read EU law, I don't think the size of the payment matters at all, as long as there is a value transfer. Firstly, the reason I'd say that, firstly, it's a by-object infringement in the EU. It's not an effects-based test, so size of payment is irrelevant. Secondly, size of payment is not a proxy for patent strength in Europe for two reasons. One, there's no Hatch-Waxman, so there's not one person to pay off. There's a potentially infinite number of people to pay off, so payment to one can't tell you actually the chances of of succeeding in litigation because it's an infinite regression and frankly, too many assumptions to make any sense of it. And secondly, because the EU patent court system is so bad, that the sector inquiry explicitly found that you get divergent outcomes in 11% of cases involving the same facts. So if you have a blockbuster, you have a 100% objective chance of winning your patent. The baseline should be 11% of your monopoly profits. That shows extreme confidence, because that's just factoring in the incompetence of the current patent, the inconsistencies of the current patent court system. And my conclusion that the size of the payment is irrelevant is backed up by the original sector inquiry report, which, if you look at page 269, the last 4 sentences say that a royalty-free license is a value transfer. But I'd be interested in other people's views on that.
Who wants to respond? Or to continue the discussion on that issue?
I don't know if I can really respond to it, but at least I can say about, I don't want people to come out of this conference and think that we would look at any kind of agreement which resolves a patent dispute and features a value transfer, and it will be automatically a restriction by object. That's not the case. I just want to mention that in what we have done is really a specific contextual analysis of the facts of each of the cases that we are looking at right now, and it's the global thing I wanted to mention. What I mentioned here in Lundbeck, we have concluded to a restriction by object, but because of the specific really facts of this case. So, for example, when I mentioned in the report, the annual monitoring reports that we do, we have there this B2 category, which can be potentially problematic, but it doesn't mean that all these settlements that we have there, and actually you see that we have not investigated, most of them are restrictions by object. We cannot conclude to that. So the monitoring, we monitor settlements, and then cases are something different.
Maybe 3 remarks, if you allow me. First of all, I think we all agree that nobody says pharmaceutical firms are not allowed to settle disputes. Nobody says this. The question is whether it is illegal to settle at particular terms. We talk about the terms and not about the settlement as such. So nobody forces pharmaceutical companies to litigate to the end. Yeah, that's number one. Number two, I think we really have to listen to the industry when they tell us why they settle at particular terms. And we have heard a lot about such reasons today. So I'm very glad that we had the representatives of the 2 sides, I would say, that agree that this should be legal. That's very interesting. The question, however, I ask myself is, well, do they employ the right currency? What do I mean by this? The point is, we know if the payment takes place and we have no entry, consumers will not benefit from early entry. We have heard that maybe there is an information problem, that it is difficult for the parties to assess and maybe to communicate and to talk about what the value of 1 day of earlier entry is. But that's a problem you also have when you pay in euros. I haven't really understood why it is more difficult if you make the currency exchange in days. I simply have not understood this argument. Maybe you have an answer to this. If you have an answer, maybe it's helpful to me. This basically points down to the indispensability requirement of Article 101, paragraph 3. Because if this is indispensable, then you actually have to agree on a pay for delay or on a reverse payment or a payment, a value transfer, and there is no other way to do it, especially by allowing earlier entry, then I agree you should be allowed to do this.
There was one question, I think, from you.
Okay, hello. So my name is Urban Guiza. I'm a student of Mr. Newell. I would just like to know a short question. Just how can you tell if a patent is strong or weak? I heard there is no legal, there is no legal basis, but does that depend on the drug? Or are there any objective factors that could help us to know that?
Well, there is no criterion in patent law which says anything about weakness or strongness of a patent. There are the normal patentability requirements, which is novelty, inventive step, industrial applicability, and it's patent examiners looking at that. They look at the technology, they look at the prior art, and they look at where you're going. But so this is a very complex analysis, even for people who know the technology very well. They often also work together with professors to give really experts in a particular field. So for a competition authority to make such a kind of analysis, it's almost impossible. So either you work together with people who have that expertise, and then we have to change some things in how things are working. Courts also use these experts, and in different countries there are different procedures to have experts to give their feedback. And so I particularly like the Japanese system, even though a lot of people couldn't care less. But so what they do there is that the IP High Court effectively have people from the patent office, really senior examiners, helping them to look at the patents, looking at the technology. So not just experts who come one time to a session of the court and give feedback, but really people who support and who, if a judge has a question about a technology or a patent or what is this word here in this patent, and can you help me with assessing novelty, inventive step, they can step in and say, you know, this is how we do this at the patent office. So at least there's a good understanding, and these kind of pragmatic solutions are possible.
I mean, there are different types of patents as well, of course. I mean, in the sense that in Europe you have different systems for granting patents. So a Belgian patent will be different than a German or a European patent, which increase as well, I mean, the complexity, because the presumption of value will differ because the process is different. You don't have an examination in certain countries, for instance, and you have it in others. But I see there are...
I mean, it's not that I disagree, but I've worked in a bunch of cases that involved patents, sometimes with antitrust and competition law implications. And when you start working with the business people, once you're actually trying to make this stuff, you know that some patents are strong and some patents are weak. You don't need professors and patent officials' help. But ultimately, when you actually get into practice, all of the IP lawyers I know, when they're actually practicing, they can, once you're actually doing the case, you can say this one is strong and this one is weak, and so that the idea that there's only one kind and that there's no such thing as strong and weak patents, that's just not true. But what it is, I think what's important, it brings in a word that we've used a bunch of times today, which is it's probabilistic, because sometimes weak patents win in court and sometimes strong patents lose in court. And it's like all of the stuff that we're talking about today, it's essentially a probabilistic exercise. And it brings to mind, as we're talking about it, one of the things about activists, which I didn't focus on when I was describing it to you earlier today, because it's not just about the IP antitrust interface, it's about the nature of antitrust analysis in its core itself. And that is essentially the role of probabilistic assessment. Because one of the things that Justice Breyer says in his opinion, he actually says, and I should have gotten it out so I could quote it to you, but basically what he says is, well, we have these kind of reverse payments, and if it means that entry doesn't happen, then that is a restriction on competition. It has an anti-competitive outcome. Now, and then he says, some of the people from the companies may well say, well, there's a 95% chance that we're going to win. He said, but that's still, I'm sort of paraphrasing now, a 5% chance that you would lose. And that risk, the possibility that there could have been competition, and eliminating that is still a lowering of competition. Now, I'm not sure that I agree with it. That's a good way to try to analyze it. But from the perspective of antitrust analysis, what it's really saying is that the risk, the probabilistic risk, the possibility that competition could be eliminated by doing something. Competition that would happen and a counterfactual will be eliminated is an anti-competitive effect, even if it's slow. That's really different from saying that there's a more than 50% chance that there's going to be a welfare loss. It's elimination of the risk. And if that's the standard for applying Section 1 of the Sherman Act, that's a very interesting, I'm not sure that they meant it, by the way, but if you actually took that seriously, that's a very interesting and important point. And it's a point that's been brought out in a number of the law review articles that I read when we came into this. And that plays through, Jen, to the final comment I want to make, is to respond to James's question about the role of the size of the settlement. I appreciate that he was asking that with about EU law, but it all comes down again, to this probabilistic problem. When what the court used, and again I should have focused on this perhaps more, is a large and unexplained amount is indicative of a weak patent. Because if there's no other explanation, and we've heard a bunch of the possible explanations, but if there's no other explanation, then that tends to say that the originating company was nervous and they thought that they were going to lose. And that plays into the probabilistic outcome. And there's no particular reason that wouldn't be valid at some level in the EU as well. I take all of the points that you made, but remember that it's about a big settlement. If somebody's made a big settlement and there are 500 generics waiting, and they're willing to pay big settlements to another, that's more and more indicative that they're worrying about something. Well, that can never be excluded. At any rate, so those were my comments.
I can maybe address the value question. And maybe one comment, I think I agree with the odd formulation about there being sort of an uncertainty that's removed. That's somewhat saying there's a restriction on conduct and that's equal to a restriction on competition without having to do the analysis, right? Because you've made a guaranteed outcome, you have some restriction on conduct, we don't have to do further analysis, that's enough. On the value transfer, why do you need a value transfer? Why is it indispensable? I think legally looking at what the competition analysis should be, the burden of proof is not why do you need a payment. The burden of proof is why is a payment a problem, right? Because you have to first identify that there's a restriction of competition, that it's anti-competitive to have the payment. Only once you have that do you need to show what the justification is. So that's an interesting kind of slant that I think the approach reflects, that somehow all of these transfers now have to be justified up front without there having to be shown that there was a restriction on competition to begin with. Now, why do you need a transfer of value? It's like, I've mentioned this, but I don't know if it's a good analogy, but I'll mention it anyway. It's like when you negotiate to buy a house. When you negotiate to buy a house, you might disagree about the price you're willing to pay. There might be a lot of back and forth, and neither party is willing to cough up the last not give in the last mile, right? You want to stick to your amount, you have your amount carved in stone, that's how much you're willing to. Then people can have other options. You throw in the furniture, you throw in the curtains. That's what it means. Modalities of negotiating, because of the fact that perspectives are very different, because it means something different, not just in a day of your sales, but also in your risk and how important is the product in your portfolio and how much other products do you have and what are your future plans with the product and where do you expect to launch it and where would you not launch it and what's your team behind the product and what's their perception. Can be very subjective perceptions too. There's a lot of different modalities, and to just say you can agree on one thing or you can negotiate with one thing and nothing else and that's time, it's very restrictive and is more likely than not to result in an outcome that's going to facilitate a settlement and facilitate entry. If you give more modalities, you just encourage people to agree on a settlement and therefore agree on a time that they can enter. That's going to more result prone.
I try to make it very quick. 3 points. First of all, many of the patent rights are found after a litigation, found invalid from according to each jurisdiction, from as low as 30% up to as high as 70%. So the logical ground for the presumption of invalidity of patent right is being questioned every day. Number 2 is that we don't question the efficiency of a settlement, efficiency of the contribution of the patent rights regime, but we are concerned about an exceptional situation where the patent rights regime does not contribute to promote consumer welfare, but it goes beyond, far beyond the design arena that the patent laws has designed to give an exceptional monopoly power to the registered patent. So, and the final thing is that about how we can see a certain payment is excessive or not. Well, yesterday I talked in the ABA conference in London that in the friend commitment violation in the IT industry. Well, the basic question is how much licensing fee is excessive in violation of the friend commitment? Well, yes, it is very, very difficult. But still, we have many economists and lawyers who said, well, we will be able to set the fair market value, fair market price of the standard technology. But in this reverse payment situation, we're setting a finding and a proper market value of the litigation cost, and is, to my eyes, is comparably easier than the situation in the friend, because we have a certain deal between two parties. In the friend commitment situation, we have one single player who setting his own price, and we have to look into the companies inside the financial status and everything. But here we have two parties, and what we need to do is review their justifications why they have agreed to pay that amount. So it is much easier than finding an excessiveness of a certain price of a single technology licensing.
Okay, thank you. I think we are coming to the end. Before giving the micro to Paul for the conclusions, I just want to mention, first of all, a practical issue, or not an issue. All the presentations will be put online for the students on different platforms that they are using, iCampus, but as well on an open platform for everybody, which is IPDigit. And in your documents, there was a short presentation of the issue on a Petablog that I'm using. I'm posting in PDF all the PowerPoint presentation into next day, so that you all have access to those documents for those who did not have a copy on paper. And then the last comment on the ground. I mean, first of all, thank you for all the speakers. I think we had a lively discussion at the end. I know a little bit about the patent issues, and it's huge as presented by Esther, but I'm discovering that there are so many, complex competition issues. And my feeling is, while hearing you speaking, for instance, about the Lundbeck case, at the end, I'm a little bit confused because I don't know exactly what a patent settlement case is and what a cartel case is. And I think that the drawing line between the two is not always that easy. And I think that there might be then a risk that some cartel cases are just presented as patent settlement cases, because there are always patents around. So basically, in all commercial transaction, you can use a patent and involve it in the scope of the transactions, because there are so many patents around because of the packet and ticket issue. So the line in between the two might become difficult to draw, and there might be a temptation to frame cartel cases into patent settlement cases. So it's a complex issue. That was a last comment.